Okay, so for the religious freedom update, I wanted to give three kind of general or two more general updates of things that are going on around the country, and then one rather specific one. As always, we could talk for hours on things that are happening around the country related to religious freedom. So these are just three very quick issues that are percolating that I think are of interest to folks. One relates to vaccinations. You may be interested to know that as the vaccine gets spread out across the country, there's obviously a lot of questions about whether or not people who have religious or philosophical objections to it will be able to opt out. Every state's going to have to issue its own orders as to mandating the COVID-19 vaccine. Right now, almost every state in the country allows for people to have religious, some states allow religious objections, some states allow religious and philosophical objections to getting mandatory vaccines in order to have their kids in school. And that goes for the traditional vaccines we tend to think of. For COVID-19, the question remains how many states are going to grant exemptions for religious and or philosophical objections to getting the vaccine. But I will tell you that just this week, a federal district court in New York ruled that a family could not get a religious objection to a measles vaccine that was otherwise mandated. And so there, the judge ruled that the law, the regulation at issue was neutral and generally applicable, and therefore the government only needed to survive rational basis review. And then now this child will have to get the vaccine. I will say, though, that the state of the law as to what constitutes a neutral and generally applicable law is quite in flux right now. And I suspect this will get appealed up to the Second Circuit, and who knows what will happen after that point. Another thing that's interesting and is percolating out there, the Equality Act, if you haven't seen it, is getting news, was just passed through the House, is getting lots of attention. Generally, I think it's a mistake to assume that every time you hear something about LGBT rights that it has to do with religious freedom. I know it's a mistake to say every time you hear something to do with religious freedom, it has to do with LGBT rights. Often that is not the case. In this instance, though, the Equality Act, and the reason I bring it up, the Equality Act specifically says that the Religious Freedom Restoration Act will not apply to its provisions. So it has a direct impact on religious freedom. The question, of course, is what will it look like once it actually gets through the Senate and there's amendments and things, changes made to it. Fairness for all principles will hopefully get included. There will be obviously lots of debates. And then, of course, whatever passes is likely going to face all sorts of challenges in the courts. And it may not matter at the end of the day if the Equality Act exempts itself from RFRA. It may not have too much of an effect on things given how the Supreme Court has been interpreting and applying the First Amendment as of late. But that is out there and it's a live issue. The other thing I wanted to show is that not all religious freedom disputes have to do with a pandemic or with culture war issues. And in fact, the vast majority do not. It's a mistake to think that those are the only two places religious freedom is doing anything. And in fact, the reality is that religious freedom is playing a major role in all sorts of areas of life that just don't make headlines because it's not sexy and is not going to get as many clicks. Let me give you an example. Just this week, the Supreme Court denied cert in a case that has been percolating out of Texas for 7 years. And what it involves is church property disputes. The Episcopal Diocese of Fort Worth withdrew from the broader Episcopal Church and joined itself with a more conservative Anglican group. What happens when that happens, though, is there's often disputes about property. Who gets the building that the Episcopal Diocese of Fort Worth was using? And you can imagine in some instances that these disputes are really a big deal. We're talking about buildings worth sometimes tens of millions of dollars. We're talking about property within the buildings. We're talking about land that is extremely valuable. The mother church wants to be able to continue to have those buildings. The church breaking away wants to keep it. And these are disputes that need to get resolved. The Supreme Court has been less than clear on this over the years. They've provided two tests. One is called the neutral principles test that essentially says, well, look, courts don't look at anything to do with the church or its views on religion or how people are connected. Instead, they just look at neutral documents like documents related to trust law and documents related to whose name is on the title for property, and that's how they decide which church gets to keep a building. In another opinion, the Supreme Court has said it's called the rule of deference. So wherever possible, courts should stay out of it and just defer to the governing church's authority. That works a little bit better with hierarchical churches. It gets to be a bit of a mess when you talk about congregational models of churches, and it becomes almost unapplicable when you're talking about churches that don't even have anything like a congregationalist model. But both options are available as far as the US Supreme Court is concerned. Texas, in this case, applied the neutral principles model and ruled that the Episcopal Diocese of Fort Worth was actually the rightful owner based on all the various documents of this building. And so that church broke away from the broader Episcopal Church and took its building with it and all of its property. The Texas Supreme Court said that was okay. The parties asked the US Supreme Court to jump in and give some clarity as to what was the right test, and the Supreme Court declined to do so this week.